Good morning. Are you Trinity Hughes? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hughes, in cause number 25 DCCR 0770, you're charged with the state jail felony offense of unauthorized use of a vehicle from May 8th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 5-year deferred probation, $500.
Welcome back to Law Nexus. We're glad you're here. Today's courtroom story begins before a single word is even spoken, because courtrooms don't just decide cases, they decide futures. Same judge, same day, same building. But by the end of this video, you'll see how one decision can mean freedom or 5 years behind bars. Watch closely, because the details matter. What starts calm quickly turns into a sharp reminder of how one choice can change a life. One defendant walks away with hope, another walks straight toward prison. Same judge, same courtroom, completely different endings. And that line, same judge, same courtroom, very different endings, isn't drama. It's the legal system in its purest form. Outcomes aren't about luck. They're about history, credibility, and whether the court believes you deserve one last chance.
And you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Hughes is not competent?
No, Your Honor.
And any history?
There's some slight history in Orange County, some cases that were refused, Your Honor, but no convictions or anything like that. So I would ask that we go forward today.
Okay. So, Ms. Hughes, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report and to find sufficient evidence to find you guilty and follow your agreement and defer all proceedings for a period of 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, then this is a great opportunity because you don't have a felony conviction on your record. And at the end of the
right here, this is massive. A 5-year deferred probation isn't a conviction. It's the court saying, prove you can stay out of trouble. No felony record, no prison, if you do it right. But here's the catch. Mess up even once and the hammer drops. This is freedom on a timer, an hourglass with the sand already running.
Period, the case will actually be dismissed. You'll never have a conviction. The other side of that is if you violate any condition of probation, you could be brought back into court, you could be found guilty of the offense, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? Also, it's important for you to know that if you get on probation, do everything you're supposed to, pay your fees, fines, show up, do everything. I sign early terminations for probation all the time. So if you do it all correctly up front, then you likely won't even have to do the whole 5 years, but that'll be up to you. You understand? So the first thing you'll do, you'll get some paperwork today before you leave. As soon as you are released from custody, you need to make sure you go to probation and get everything taken care of. Okay, good luck to you, ma'am. All right, so we're going on.
Yeah, it's a third degree.
Okay, so more of it. All right, so are you Perry Robertson?
Yes, ma'am.
Listen closely to how the judge frames the choice here. Opportunity versus consequence. If she succeeds, this case disappears like it never existed. If she fails, she comes back in cuffs, not with excuses. This is that quiet pressure point most defendants don't fully understand until it's already too late.
Your client waived the formal reading of the indictment in each case.
Your Honor.
Mr. Robertson, in cause number 25 DCCR 0498, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from March 23rd of 2025. The indictment alleges you were previously convicted of evading detention February 23rd of 1998, and then again January 10th of 2000. And then it further alleges you were convicted previously of possession of a controlled substance, a state jail felony, April 22nd of 1999. Then after that was final, you were convicted of delivery of a controlled substance, a state jail felony, November 20th of 2000. And then after that, possession of a controlled substance, a state jail felony, November 4th of 2003. And then convicted of two delivery of controlled substance, state jail felonies, June 13th of 2005. After that, convicted of possession of a controlled substance, a state jail felony, February 19th of 2008. Again, convicted of possession of a controlled substance, a state jail felony, April 12th of 2010. And unauthorized use of a motor vehicle, January 7th of 2010. And then finally, possession of a controlled substance, a state jail felony, July 29th of 2024. And how do you plead to that charge? Are all of those prior convictions true? Did you enter your plea of guilty and true to all of those convictions freely and voluntarily?
Yes.
And because they're all actually true?
Yes.
All right, I do want to know, what was that what did he get last year?
Wait, I believe,
Possession of a controlled substance, July 29th, 2024. Cause number 24, DCCR 0025.
state jail.
State jail, Your Honor.
State jail
Give me
time?
a second.
Yes, state jail.
Okay. You ever been to TDC on any of these cases? Okay. So you understand if I follow that agreement, you're waiving your right to appeal, right?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Robertson is not competent?
No, Your Honor.
And the agreement is for a dismissal in 0499, correct?
No, there's
No,
two
he's
cases.
Two cases, Judge.
What did I just read?
CC.
Oh, to run CC. Sorry. Let me go through. So then, that helps me. Hold on. I got to write this. All right, in clause number 25, DCCR 0499, you're charged with, give me a second, the state jail felony offense of burglary of a building from March 7th of 2025. This indictment alleges all of those same prior convictions that I read out previously. And how do you plead to this charge? And again, are all of those prior convictions true? And are you entering your plea of guilty and true in this case freely and voluntarily? State tenders number one in that case as
No
well.
objection.
It's admitted. Any evidence that Mr. Robertson's not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. And cause number 25, DCCR 0498, finds you guilty of the state jail felony offense of evading arrest or detention with previous convictions. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 0499, also find that you entered your plea of guilty freely and voluntarily and those pleas of true. find sufficient evidence to find you guilty, and at this time find you guilty, find those prior convictions true, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you, in each of those cases, the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. They will run concurrently, which means together at the same time. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. You go back with the bailiff.
You don't need to tell me all that. I just read.
I know.
I started laughing. I said, I guess you have.
Yeah,
I tried to say, look, paperwork does. Man, I know all this. I can just say.
he probably could. DeMarcus Senegal.
I'm going to tell you all later on about he should have changed the name.
Oh,
Oh my God.
good morning.
Good morning. How are you? I
Good.
What he says is pretty bad. So I'm pretty glad. Surprised you didn't. I don't think I need those discovery certifications.
Good morning. Are you DeMarcus Senegal? And will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Senegal, in cause number 20-33924, I have a motion to revoke your community supervision. Shows that you were placed on probation November 30th of 2020 for the offense of deadly conduct discharging a firearm, a third-degree felony, and that was a 10-year term in prison that was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you provided a urine sample June 2nd of 2025 that tested positive for cocaine. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample July 3rd of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample August 14th of 2025 that also tested positive for cocaine. Is that true or not true? And then count 4 alleges that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Senegal is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I may have gone over that with you, but I don't think I started that in 2020. But because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide
And
you to
now
see.
watch the tone shift. Same courtroom, but the energy drops instantly. When a judge starts listing prior convictions, that's not small talk. That's a warning. This is the moment when the past walks back into the room.